You are for the respondent. Have you taken?
Petitioner, there is an interim order, my lord, made.
As prayed for by Mr. B. Gogoi, learned Standing Council
Taxation.
which is not opposed by the other side, list this matter on 19/8/2024. Stop interim, if any, shall continue till the next date of listing.
I'm extremely obliged.
Please, Lordship, with the consent of the other side, I beg to mention item number 22. Lordship, we are for the respondent department. Lordship, we are reconstructing the file. We have also informed the other side to furnish a copy. Lordship, we will take instructions in the matter since it's pending matter.
You have informed the other side?
Yes, Lordship.
As prayed for by Mr.
U. Sharma.
U. Sharma, Learned, Standing Council,
No,
PNRD?
Lordship, I am appearing on behalf of the Standing Council.
PNRD?
Yes, Lordship.
On behalf of the Standing Council, PNRD submits that you have reconstructed.
Lordship, we are reconstructing. We have
Submits
also
that
requested.
the office that his office is reconstructing the records of the instant writ petition. Accordingly, he seeks some accommodation in the matter. Prayer is not opposed. List this matter after
Lordship, after the vacation, perhaps.
after 3 weeks on a date to be fixed by the registry.
Obliged.
May please, Your Lordship, with respect to item number 14, Lordship,
Item number
item number 14, Your
14.
Lordship may not be inclined to take up the matter as Lordship had appeared
All
in
right.
this case for the
List before any other bench without me.
May I please, I beg to mention item number 40, my lord.
140
40, my lord.
is
taken
a
after 10 days.
bail hearing.
Yes, my lord.
Yes,
But up-to-date CD will be required.
it's not available.
It is available, not up-to-date.
Call for up-to-date CD. List again on
My lord,
On 27.
on 27. So and so. Interim is there.
yes, my lord. that
Interim, if any, shall continue till the next date of listing.
Obliged,
Yes.
my lord.
May I please, Lordship, by taking consent from the other side, I beg to mention item number 27, Lordship.
27.
Yes, Lordship. Counsel for the petitioner is unable to appear today due to his illness. Lordship may kindly adjourn the matter for today.
You are for the respondent.
No, Lordship, for the petitioner.
Petitioner.
Be not.
As prayed for on behalf of Mr. B. Nutt, list this comma which is not opposed by the other side. List this matter again on.
After 2 weeks,
List
Lordship.
this matter after 2 weeks on a date to be fixed by the registry. Yes.
May I please, my lord? My lord, with the consent of other side, my lord, item number 43, my lord. It is in orders column, my lord. We need to.
You have already heard this court has made it very clear in the beginning that no or mention for orders matters. So please wait for your turn. Everybody will be accommodated, but when a matter is listed for orders, this court would like to open the file and see why the matter is placed before the court. Yes. Next.
So, my lord's kind indulgence, my lord, item 35, my lord, question please to fix it on 19th of August, my lord.
35 orders already passed.
Yes, well, instead of 19th, maybe on 20th or 19th there is
Have
something.
you informed the other side?
Well, I have taken consent of that.
When do you want it?
20th, my lord, any day other than 19th.
20. It's not
I'm
19.
extremely obliged.
Okay.
May I please, Your Lordship? I beg to mention item number 26 of today's daily list, Lordship.
26.
Yes, Lordship. I have taken consent from the other side, Lordship.
You are for?
Industry and Commerce Department, Lordship.
As prayed for by on behalf of the Standing Council, Industries and Commerce Department, comma, which is not opposed by the other side. List this matter after 2 weeks on a
Lordship,
date
after a week, Lordship.
after a week on a date to be fixed by the registry.
Date may be given.
All right. Next.
Obliged.
May it please your Lordship, I beg to mention item number 18. Due to some
1
personal
8
difficulty, my senior will not be able to appear today.
1 8.
1-8.
It's an 18 matter. You are for whom?
Petitioner.
What is the reason for adjournment?
Lordship, he will be out of station.
Who?
D. Mazumdar.
As prayed by MS
D.
D.
Devi.
Nath.
Devi.
D. Devi, Learned Counsel for the petitioner, on the ground that Mr. D. Majumdar, Learned Senior Counsel, leading her is out of station, comma, which is not opposed by the other side. List this matter on
After 2 weeks.
at a date. 26, comfortable? Okay, next.
Obliged.
May I please your Lordship? Lordship, I beg to mention item number 19. We have taken the consent of the other side.
I'm for the respondent, Lordship.
I'm for the
We have no objection.
As prayed for by MS
Jay Sharma on
Jay
behalf
Sharma,
of
learned
S. Ali.
counsel for?
S. Ali.
No, you are for whom?
Petitioner.
Learned counsel for the petitioner, which is not opposed by the other side. List this matter 2 weeks or pisar that date did you on such and such date. Next.
May I please, Lordship, with the consent of other side, I beg to mention item number 20, Lordship.
20.
20, Lordship.
Yes.
We adjourn for today, Lordship.
Ms. Aike, you are appearing in this matter?
I am appearing for the railways.
You are appearing? Any objection?
There's some difficulty.
As prayed for by Mr.
R. Sarkar.
R. Sarkar, learned counsel for the petitioner, which is not opposed by the sending council NF Railway. List this matter again on 27.
Much obliged.
May I mention?
Yes.
Well, Mr. Kolita has mentioned one item number 26. I am the petitioner dear. They asked for next week, my lord, because some urgency there, July month, I will not be here.
When do you want it? When do you want it?
Next week, my lord. It's when 21 matter, my lord.
In item
Yes,
26?
Yes, my lord. Next week,
Any
any day.
date next week? Item 26. Is 21 all right with you?
Yes, 20 by 21. 20 it can be disposed of. It's a whole
21st.
matter.
All right,
Okay.
next please.
May I please, Lordship, proceed with the consent of other side. I recommend item 28, Lordship. Yesterday we got the affidavit, Lordship. So
You have?
Yesterday, I am the petitioner, Lordship.
You want to file a reply?
Yes, Lordship.
As prayed for by Mr.
D there, Lordship.
D. Dale Learned Counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry to enable the petitioner to file rejoinder to the affidavit in opposition filed yesterday.
Yes, sir.
Filed yesterday, I so and so date on behalf of the respondent number
2, 3, or 4.
2, 3 and 4. Yes, next. File up.
May I please, Lordship? Lordship, I beg to mention item number 17, Lordship, on behalf of S. Chaudhary. Lordship, here we will file reply. We have to take instruction, Lordship.
You are for the petitioner.
Yes, Lordship.
When was the affidavit filed?
Uh,
You wait, I shall accommodate, but wait for your turn. It's an 18 matter.
yes, Lordship.
Just wait for your turn. I'll see the file once. Yes. Call the list, please.
May I please, Your Lordship? On item number 32, we have an interim order prevailing, my lord.
In item number?
32. That has been adjourned by the respondent, my lord.
In item 32, interim, if any, shall continue till the next date of listing.
Highly obliged.
For motion, item number 1.
At Your Lordship, for 30th application in connection with Ramdan's PS case number 3 of 2024.
Yes, yes. 438.
438.
Earlier disposed of similar FIR.
I don't have any idea regarding this. Crime branch, these cases are taken by different court actually.
But anyway, you take
Yes, madam.
CD.
CD, madam.
Offences under
120B, 420, 409.
All right, let him obtain instruction. Call for CD, list on
My lord, on 24th.
24th.
Petitioner is a lawyer, Lordship. Then she was newcomer.
Next.
Item 2. 24. May I please, Lordship?
Yes.
This case, my the petitioner has, my lord, some interim prayer, Lordship. Kindly see, my lord, the page 10 was the petitioner retired on, my lord.
FIR is at page.
Affair is at 11, Lordship.
You are
I am retired Lat Mandal, Lordship. I was not there, Lordship, at that relevant time, Lordship. He was on Dibakar Kakoti was the Lat Mandal.
Hayat Ali.
Hayat Ali, my lord. I am not. I retired in 2000. My lord.
All right, let CD.
My-
Short date.
Short date.
Yes.
My lord, what I am submitting, Lord, this
Short
circular.
date.
My lord, on 19th.
My lord,
19.
circle officer has been, my lord, granted period.
Call CD, list on 19.
My lord, one thing is here I would like to point out, my lord. My learned friend is saying that circle officer has been granted interim
Yes.
by Honorable Justice A. Chaudhary. I don't know why this matter has been listed here. The order has been
My lord, kindly see that is there
annexed by him, my lord.
at page 20,
One
Lordship.
FIR, I think this court has also disposed of.
Disposed of.
And the other AB is still pending. There is no order yet.
My lord, page 20, kindly see, Lordship.
Yes. Yes, Mr. Ganguly. Have you taken steps?
With apologies, my lord, we have taken steps yesterday. What has happened, my lord, is that the petitioner's, my lord, very unfortunate case, his young child, his young son died of an incurable disease, my lord. And he, my lord, was out of communication for a long time.
But have you taken the steps?
We have taken steps yesterday, my lord.
Yesterday?
Yes, yesterday we have taken steps.
Mr. A. Ganguly, Learned Counsel for the petitioner, submits that the fresh steps as directed by this court by order dated 13/3/2024 has been taken yesterday. Stop.
Yes.
In view of the aforesaid endorsement made by the Learned Counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry.
The interim order passed earlier.
Interim, if any, shall continue till the next date of listing.
Habla.
New incumbent.
Yes. There has been new incumbency.
All right.
Nasimul Haq.
I'm disposing it off, allowing
Yes,
it.
Your Lordship.
Even item number 5 is same.
Same, Your Lordship.
How many IA are there? 2 IA?
2 IAs.
Item 4 and 5 will be same, but it may be different numbers. So, okay. Heard, Mr.
R. Paul.
R. Paul, Learned Counsel for the petitioner. Stop. No one for respondent, no? This is an application under Order 1, Rule 10 of CPC for implement of. Don't say all that. This is an application for implement of new incumbent as respondent number 8 in the connected contempt case C number 276 of 2019. Stop. It is submitted by the Learned Counsel of the applicant that during the pendency of the contempt petition, there has been major reshuffling for various posts by the government, and a new person has taken up the position previously held by the contemptor number 7. Stop. Accordingly, this implement application has been filed to bring the new incumbent on record as an arraigned contemptor. Stop. Heard the Learned Counsel for the applicant and peruse the affirmance made in the implement application. Stop. It appears that the presence of the new incumbent. Where is the details of the person?
Annexure 1, Lordship. Nasimul Haq.
You want Nasimul Haq to be a new incumbent. I, Nasimul Haq, Chief Engineer, Public Health Engineering Department, Hengerabari 781036 Assam, is an essential and necessary party for effective adjudication of the contempt petition. Stop. Accordingly, the prayer of implement is allowed. As such, so-and-so is impleaded as respondent number 8 in the contempt petition 276 of 2019. I disposed of. In the next, it will be R6 instead of 8, okay? And R5 is the previous, R6 is the new. And the name is at page?
Name is at page, Lordship. That is Annexure 1, Lordship.
Annexure 1 page?
Page 10.
Page 10, the name of the new incumbent, okay? Both disposed of.
Highly appreciated.
Disposed of Peter Lekhiloba. And in the, Mr. Counsel, 1 second. In the contempt petition, in view of the aforesaid impleadment, let amended cause title be submitted to the office of the registry for doing the needful. Stop. And then issue notice, returnable
4 weeks.
4 weeks. Steps within the period of 3 days from today. List after 4 weeks on a date to be fixed by the registry. All right. In both the contempt, huh? Yes, please. No, 6. 5 is done. 4 and 5 same order, disposed of. Likhil order. confusion over disposal.
May your pleasure, Lordship.
Yes.
Lordship, my senior is leaks in another court. Kindly time link for.
Time link corridor. All right.
May it please your Lordship. This item is related to eviction matter, my lord. Interim order is there, but my lord, the latest position I don't know, my lord. So let them file affidavit.
Lordship grants me about 2 weeks time. I'll respond.
Let it come first week of August because July I will not be here.
All right, that is okay, Miss Sharma. So I will say that you will have the up-to-date instructions, correct? As prayed for by Ms. S. Sharma, learned government advocate for the state respondent, list this matter after the vacation at the date on such and such date to enable the state council to place the up-to-date instruction in the matter.
9th August. Oblige.
Yes, Mr. Goswami.
In this case, my lord, petitioners prayed against their eviction, my lord, from a place in which they were running their business. Your lordship had even passed orders in the earlier part, my lord, particularly one order 442.
Yes, I have it.
Yes, two issues were there, my lord.
Lordship, yesterday I filed my affidavit.
You filed your affidavit?
My lord, your lordship will just allow me to submit, my lord.
But that affidavit is not on record.
It has not come. It has not come. It was filed yesterday. But let me just submit, my lord. Two issues, my lord. One is the status of the proposal for allotment of land in my favor. That is one issue. And number two, how the land had gone to the municipality. So far as the transfer of land to the municipality, they have explained in their affidavit, and this affidavit is filed by my friend on behalf of the municipal board. So that is there. We will prefer reply or whatever. But then the other issue is not addressed here. The status of the proposal, my lord. Second paragraph of order dated 4/4/24, my lord. It further appears from the order dated 13th that though some instruction was given by District Development Commission.
It is not clear as regards the status of the said application for settlement.
Yes, ma'am.
This part is not addressed.
This part is not addressed. But they cannot do it. This has to come from District Commissioner.
Who is for the DC? MS Sharma. You have this instruction, Mr. Sharma? Just hear out the order. In terms of the order dated 4/4/2024, it is submitted by Mr. J. Hendick, Learned Counsel for the Respondent Municipal Board that an affidavit has been filed yesterday, I so-and-so date. Stop. Though a copy of the same has been served on the Learned Counsel, Mr. B.D. Goswami, for the petitioner, the same is not available on record. Stop. Let registry verify and place the said affidavit on record. Stop. It is submitted by Mr. B.D. Goswami, Learned Counsel for the petitioner, that in the affidavit filed by the municipal board, the query of this court as regards the status of the
application for settlement of
land of the subject land is not addressed.
Yes,
stop.
In favor of the petitioner.
In favor of the petitioner is not addressed by the municipal board. He further submits that the said issue is required to be addressed by the district commissioner, by the jurisdictional district commissioner. Stop. In view of the aforesaid endorsement made by the Learned Counsel for the petitioner, let respondent number. Let MS S. Sharma, Learned Government Advocate for the state respondent, obtain instruction and or file affidavit on behalf of respondent number. Respondent number. Ms. Sharma, respondent number. Respondent number 3, addressing specifically the issue of the status of settlement of the subject land in favor of the petitioner. Stop. A copy of the aforesaid order be furnished to the respective councils. 2 and 3. Affidavit by 2 and 3.
Earlier affidavit was filed by 3. So 2 has been filed. Much obliged, my lord.
Ms. Sharma, just obtain that specific instruction. If you wish, you may file an affidavit or you can place that instruction. What has happened to the
Status of these applications?
Yes.
Well, the matter will be listed next after vacation.
You want a date?
After vacation, will come.
List this matter again after 3 weeks on a date to be fixed by the registry.
Master.
Yes, Your Lordship.
Yes, Ms. Kope.
Lordship, this matter is relating to exemption under the industrial policy. But Lordship, by order dated 7/2/24, Lordship, this matter was already admitted, Lordship. It had to come for hearing, Lordship.
Yes. It appears from the order dated 7/2/2024 that this matter has been wrongly listed in the column admission. Stop. Let this matter be listed for hearing in its usual course as directed earlier by this court.
Much obliged.
Here, please, Lordship.
Yes. Item number?
Yes, Lordship. Here we will file reply. Lordship, here
You are
we will
filing a reply?
Yes,
You are for the
Lordship.
petitioner?
Yes. We have to take instruction, Lordship, whether he has received the
The
amount.
affidavit, Ms. Gayan, which you are required to file in terms of the order dated 11/3 has been filed?
11/3, my lord. Here, my lord, actually for joint verification and for that is actually here, my lord, there is requirement of.
No, Ms. Gayan, my specific query is there was an affidavit which you had said you were going to file.
Oh, yes, my
correct?
lord. Yes.
Has that been filed?
No, my lord.
It has not been filed.
I'll
What
file it.
reply you want to make? To which affidavit? This is the matter which was being mentioned during the mentioning hours.
Additional affidavit, Lordship. Additional affidavit.
You want to file an additional affidavit?
No, Lordship. An additional affidavit was filed, Lordship. We have. Here we will file reply, Lordship.
I'm sorry, I'm not understanding what you want to do.
On 27/3/24, Lordship.
Yes, my lord, we have filed it.
You have
Sorry, my
filed.
lord. Yes.
Ms. Gayan, you must be mindful.
Yes, sir, sorry.
As your name, please.
R. Medhi.
MS R. Medhi, Learned Counsel for the petitioner, seeks 2 weeks' time. 2 weeks. How much time?
Lordship, after vacation.
2 weeks' time to file reply affidavit to the affidavit filed on behalf of the central government in terms of the order dated 27/3/24 and 11/3/2024. Stop. Prayer allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
Yes, GMC. Mr. Bora, affidavit file.
Need some more time to file the affidavit because.
How much time?
1 week time.
Any objection?
Okay, Lordship, if they are going to file
Mr. S. Bora, Learned Standing Counsel for the GMC, assures that the affidavit, that the requisite return shall be filed within a period of 2 weeks from today. Stop. In view of the aforesaid assurance made by Mr. S. Bora, list this matter after 3 weeks on a date to be fixed by the registry.
Lordship, there is interim, Lordship.
Interim, if any, shall continue till the next date of listing. Needless to clarify that the affidavit shall be filed positively by the next date of listing, failing which matter shall be proceeded in accordance with law.
Okay. Lordship.
Lordship, this matter might be possible for time being, Your Lordship. My senior is on line, sir.
Possible. All right. Yes. Affidavit in reply.
You are supposed to file affidavit.
What happened to your affidavit in reply? Why are you looking behind? You don't know? You're not in the matter? It's a basic question, Miss Counsel. You must be aware whether as regards the status of the pleadings of your case, this is not an instruction you need to rely on your senior. Mr. Mondal, you are appearing in this matter?
Yes. my lord,
Yes.
in
What
this-
is the status of the affidavit in reply?
Yes. Now, my lord, in the affidavit in reply, my lord, there is a. It is seen, my lord, civil suit is pending between the
Have
parties.
you filed the affidavit in reply?
We need not, because since civil suit is pending between the parties, my lord, let it be decided by the trial court, my lord, by disposing the, my lord, writ petition. Once the civil court is taken the, my lord, cognizance, I think it will be better to, my lord, settle there.
You want a disposal of this petition?
Yes, yes.
On
See,
what ground?
Because civil suit is pending between the parties.
What is the issue
As
involved?
As it appears before the, my lord, honorable court, in the affidavit, lordship will find at page 22. Page 22 of the, my lord, affidavit in opposition, filed by the respondent number 8 and 9.
Affidavit filed by
Respondent number 8 and 9.
at page
At page, my lord, 22.
22. This is Annexure 7.
My lord.
Yes. What do you want to show from here? There is a civil suit pending.
Yes.
Title suit.
Title suit.
For declaration of right title interest recovery. This is regarding the same property.
Same property.
This has come out in the affidavit filed by
The respondent number 8 and 9. R8 has filed this suit, my lord.
and where is the prayer in your petition?
Prayer lordship will find at page, my lord, 12. In fact, my lord,
12.
Yes.
Allot settle the land measuring 1 bigha so and so.
My lord.
Now, in relation to the said land, there is a dispute,
There is a dispute.
and that dispute is pending before the civil
court.
So
and,
what
we are in possession.
you are in possession. So then, are you withdrawing this writ petition?
Now, my lord,
Because what order do you want from this court?
my lord, my submission, my lord, since civil suit is pending between the parties, my
Yes.
lord, let the civil suit is, my lord, decided.
That the court below is obviously entitled to dispose. It doesn't need an order from this court, right?
My lord.
Now, in view of the pendency of the civil suit, in view of the dispute, there is no case made out. Either I am going to dismiss the writ petition or you withdraw with liberty. But this court cannot be directing the court below, the civil courts to dispose of the title suits that they will do. Why a direction is required?
That is.
Yes.
That is.
So dismissal or withdrawal?
Now, my lord, in this case, let it be next week, my lord. In the meantime, I will take instruction, my lord.
You take instruction because otherwise that is the ground taken by the government, right? Government, Mr. Chetia, because there is a dispute. If there is a dispute, how will you make the allotment? I am dismissing it then. Why to keep this matter? That is the ground?
Yes, ma'am.
Yes? Alright, Lekha. Heard Mr. M.U. Mondal, Learned Counsel for the petitioner. Stop. Also heard Mr. M. Chetia, Learned Government Advocate for the state respondent, and Mr.
B.B. Kakoti for 8 and 9.
Mr.
B.B. Kakoti.
B.P. Kakoti for respondent number 8 and 9. Stop. By by filing the instant petition under Article 226 of the Constitution of India, comma, the petitioner is seeking a direction for allotment stroke settlement of the land measuring 1 bigha, 2 katha, 9 lecha in favor of the petitioner, comma, covered by DAG number 71 old, comma, 83 new at village Patakata Part 2 under Athani Revenue Circle, Athani, by cancelling the order dated 12/10/18 in the name of the respondent number 8 issued by the ASO Athani. Stop. Inter alia koi diba, seeking direction of seeking inter alia. Tapsat lekha. Heard the parties. Stop. It appears from the affidavit in opposition filed on behalf of respondent number 8 and 9 that a title suit has been filed, a title suit being TS number 39 of 21 has been filed by
respondent number 8.
By the respondent number 8 for declaring right title interest recovery of khas possession in favor of the aforesaid subject land. Stop. It appears the said suit is pending adjudication before the court of Munsif Bilasipara. Stop. It further appears that the stand of the government is that the stand of the state government, state respondent is that pending dispute of the subject length, the prayer sought in this writ petition cannot be addressed. Stop. In view of the dispute as regards the ownership of the subject length, this writ petition, this petition under Article 226 of the Constitution of India is not maintainable. Stop. As such, the writ petition stands dismissed. Disposed of.
His dismissal may not affect the suit pending between the parties. Otherwise,
needless to clarify that this order shall not be constrained to
the civil suit pending before the
not be constrained to effect any pending proceedings.
Developers.
Yes, disposed of.
Item 29.
28 Item 28 is there?
29.
28 mentioned. Yes.
May I please, your Lordship?
It's an impleadment.
Lordship?
You want some impleadment?
Yes, Lordship. I have filed impleadment petition on today, Lordship.
Huh?
Today itself I have filed impleadment petition.
I don't think it is on record.
Lordship.
Okay. Your name?
J.M. Gogoi.
Mr. J.M. Gogoi, Learned Counsel for the petitioner, submits that an impleadment application has been filed in the instant matter. Stop. However, the same is not on record. Let registry verify and tag the IA along with the writ petition and place the same before this court next week. Next week on any date fixed by the registry.
Obliged.
Please, Your Lordship. In item 30 and 31, I am praying for only 1 week time to file affidavit, Lordship.
Against the reply. Your name?
My name is B.B. Kakoti.
Mr. as prayed for by Mr.
B.B. Kakoti.
B.B. Kakoti, Learned Counsel for the petitioner, list this matter after
1 week.
After 1 week on a date to be fixed by the registry to enable the petitioner to file reply affidavit against the affidavit in opposition filed by the respondent number?
Respondent number 15 in 232.
15 in 32 and
6 in 709.
And 6 in 31. Duta is a set.
Obliged.
Some instructions were required in this matter. Yes, Mr. Chetia.
Yes, ma'am. In this case also, my lord, civil case, title suit is also pending.
Sorry.
In this case also, my lord,
There's a dispute?
Dispute, my lord. Title suit is pending, my lord.
Where?
Regarding management committee.
Where?
We have not filed it. We have received instruction.
No, but do you have the
Instruction.
do you have the title suit number?
It's annexed. I don't have that number.
It's annexed in the petition only.
Where?
Annexure 1, page number 19.
Annex 1.
Page 19. Title suit number 379
Yes, ma'am.
of 21.
No, but this is this is item number
33.
33.
33.
So here the prayer is for allowing the committee to work as office bearer. Correct.
Lordship.
Now, what dispute is there?
Regarding the formation of committee, my lord, their title sale is pending.
Where is that page? Annexure 1.
Page 19.
Page 19, annexure 1.
That is pending.
Yes, Lordship.
Then how this writ petition is maintainable?
The election was conducted, but however, it turned out to be a failed election.
No. What have you challenged in the title suit? Appointment and receiver. Petitioner's case is the petitioner has filed the present suit for declaration, account, appointment of receiver and for permanent injunction. So you've already filed. Then how you have filed another writ petition for the same relief?
That issue is regarding the election of the new committee, Lordship, and that the new committee which was elected turned out to be a failed election, and therefore some members of the committee has filed this title suit, and in that case there is a restraining order against the newly elected committees. So as on today there is no committee of the Governance Committee.
What do you want in this writ petition? What do you want?
We want a direction from the Deputy Commissioner to intervene into the affairs of the committee.
You see that the factum of the genuineness of the committee is now before the civil court.
Yes.
There is a dispute.
Yes.
Now, until and unless that dispute is sorted out, how can this court direct the Deputy Commissioner?
We are the old committees, Lordship. We are the old committees.
Correct. I understand you are an old committee, but the suit is also against the same issue. There is a dispute, isn't it?
Lordship.
Then, as regards the formation of the new committee, and that dispute is right now pending before the trial court, correct or not correct?
Lordship.
Now, in that situation, how can this court direct the Deputy Commissioner to look into the affairs of the new committee, formation of the new committee?
Not as an interim order, Lordship.
Sorry?
As an interim order.
How can this court grant an interim order when the matter is pending there?
What I mean to say is...
No cases made out, Mr. Counsel. You'll withdraw, I'll dismiss.
In that case, my senior may be heard, Lordship.
No. This is not a trial and error going on. If you are... No.
Because in the earlier occasion also...
You are seeking direction to allow the earlier committee, that is your committee,
yes,
to work as the office bearer of Guwahati so-and-so and to manage the affairs on so-and-so. And the suit is also filed by you. Who has filed the suit? Title suit is filed by?
Party's name is not reflected.
No, it is there. Shamimuddin.
Shamimuddin.
Who is Shamimuddin?
He is a member of the committee, Lordship.
Which committee? Earlier or new?
That information we have.
Mr. Chetia, please pass on the instruction that you have received.
Yes, sir. Because, my lord, title suit is pending, my lord, they have not taken any action.
The only problem is this order does not, it's not clear who has filed. Because if I have to dispose it of, where is this application 22/3/2022?
In page number 41, Lordship.
40?
41, Lordship. Annex 2.
This person who has filed the title suit is a member of the Guwahati Kabarstan Committee. He's
Yes,
a member?
Lordship. Yes, Lordship.
The plaintiff is a member?
Yes, Lordship.
All right. Item 33. Heard Mr.
L. Sankam, Lordship.
Mr.
L. Sankam, Lordship.
Mr. So and so, learned counsel for the petitioner, Nam to Lulubo. Also heard Mr. M. Chetia.
May I submit one thing, Lordship?
Yes.
We are just praying for running the committee.
I've understood. Also heard Mr. M. Chetia, learned government advocate for the state respondent. Stop. The petitioner, by filing the instant petition under Article 226 of the Constitution of India, the petitioners who are members
of the whole committee,
who are members of where have you described them? Who are members of the earlier office bearers of the Guwahati Kabarstan Committee has filed the instant petition under Article 226 of the Constitution of India, seeking direction inter alia to allow the earlier to allow the said earlier committee of Guwahati Kabarstan Atgao to work as the office bearers of Guwahati Kabarstan and to manage the affairs of the Guwahati Kabarstan. Stop. Heard the parties. The facts of the case is that the members of the earlier committee of the Guwahati Kabarstan Committee filed an application before the Deputy Commissioner Kamrup Metro by letter dated 22/3/2022 seeking intervention of the Office of the District Commissioner to allow the whole executive body of the Guwahati Kabarstan to run and function as the committee members till a new committee is formed. Stop. It is submitted at the bar that a title suit as regards the formation of the new committee is pending adjudication in TS number 379 of 2021 before the Court of Civil Judge 1, Kamrup M. Stop. Mr. M. Chetia, Learned Government Council, submits a copy of the instruction received via letter dated 8/4/2024 to the effect that the state respondents, due to the pendency of the civil litigation before the Civil Judge 1, Kamrup Metro, no action could be initiated on the application filed by the General Secretary Guwahati Kabarstan Committee dated 22/3/2022. Stop. I have perused the aforesaid instruction placed before this court. Stop. It further appears that the Circle Officer Guwahati Revenue Circle was directed to cause an inquiry into the matter and submit report, which is also enclosed in the instruction placed before this court marked as Annexure A.
Sorry to interrupt, but Lordship, there is a restraining order in this title suit, Lordship. The relevant portion is case number 23, Lordship.
In that case, my lord, if there is a restraining order, my lord, even though also if somebody violates that order, my lord, they have to oppose the civil court under order 39 rule 3, my lord, on violation of that order.
Stop. A copy of the said instruction is kept on record and marked as X. Then be that as it may, next paragraph, be that as it may, comma, it appears that as regards the issue of formation of new committee, a dispute is pending for adjudication before the civil court. Stop. Unless and until the aforesaid dispute is adjudicated by the competent court, comma, the prayers sought in this writ petition, in the opinion of this court, is not maintainable. Stop. This court under Article 226 cannot go into the disputed questions of facts. Stop. Hence, no case is made out. Writ petition accordingly stands dismissed. No cost.
My lord, the matter pertains to acquisition, my lord, compensation. But at the outset, I should clarify, my lord, this is not the compensation sought by the petitioners is not for acquisition of land. The compensation sought by the petitioners on the basis of a letter issued by the NHIDCL itself, my lords. My lord, that letter, my lords, would find at page 36. Thereafter, I'll narrate the facts, my lord. My lord, may kindly 36.
Lordship, before he submits.
I think on the last occasion,
yes,
Mr. R.K. Talukdar had taken time to receive instructions as regards the communication available at page 36.
Yes, Lordship.
Exactly.
My senior is not here now. He's coming. He has some personal difficulties, but he's coming.
Huh?
My senior R.K. Talukdar, he's coming. He has some personal difficulties till then. So can it be after some time?
I'll take it tomorrow then.
Tomorrow, my lord.
It is submitted that Mr. R.K. Talukdar, Learned Standing Council of the NHIDC, has some personal difficulty today. Stop. As such, list this matter again.
Day after tomorrow, if it's possible.
On so and so.
Deeply obliged, my lord.
Only 33 নেকি 33 নেকি 60 ফুট হইতে লাগছে
Yes.
May I please, Your Lordship? My senior is coming.
Your senior was, this is something which you have
Lordship,
already mentioned.
The matter is tenancy land. I have been possessing the land.
Ms. Bordelais, you are in this matter?
Our name has not been reflected in the cause list, Lordship.
Are you prepared or not prepared
Please the
today?
file. No, Your Lordship. Please the file.
List this matter.
So that may be fixed, Lordship.
Yes, when? I'm asking you, when will your senior be available? The name of the Revenue Council is not reflected in the cause list, for which he is not prepared today. So when do you want it?
As Your Lordship, please.
No, any date? Tell me, Ms. Bordelais, Mr. Council. List on such and such date with direction to the registry to reflect the name of MSN Bordelais, Learned Standing Council Revenue in the cause list.
My Lord, after vacation, my Lord.
Yes,
After
Your
summer vacation, my Lord.
July 16.
Obliged, Your Lordship.
N Bordelais, right?
Yes, Your Lordship.
Oh, there's no other initial in between.
Sorry, my lord, I was not present.
20?
3, my lord.
20?
23.
Yes, yes.
I'm being, my lord.
Yes.
Here, my lord, may I submit, my lord, one thing? Because here...
R3 has filed an affidavit. Any other affidavit was required?
No affidavit has come up.
Mr. Borthakur?
Lordship, here, Office of the Chief Secretary has been asked to give compliance of that order, Lordship.
Which
Even
order?
though we are a party, the order in the PIL that is sought to be enforced through this writ petition.
You want some time?
Some time may be granted.
For what? For instructions?
Instructions.
Mr. I. Borthakur, Learned Standing Council?
Forest Department.
Forest Department submits that there has been some development in the matter.
No development, Lordship. The Office of the Chief Secretary has to deal with this issue, Lordship.
Submits that instructions has to come from the office
of the
Chief Secretary.
Respondent 1.
With stroke respondent number 1. Who is appearing for R1?
Government advocate.
Is government a party or not?
Yes.
They are not represented? Nobody for government? Because you see, if instructions has to come from R1, then no point of adjourning on the request of Mr. Borthakur. What will he do?
Chief Secretary also is party.
But who is appearing?
And Commissioner and Government Revenue Department.
However,
and DC.
When the matter is called, none represents the central government. When the none represents the central government.
State government.
State government. State government council. Nobody is here. Ms. Burman is there.
Here 2 meters, Miller, actually.
1 second. Ms. Burman, the stand of the forest is that it is from the Chief Secretary. The concerned instructions has to come. So you obtain. First of all,
In this matter, last occasion, the forest has taken time to file affidavit.
But now he has received instructions and he just submitted that it is the Chief Secretary.
Because that particular land in question that happens to be the wildlife sanctuary matter. To that extent,
there are
a
lots of contesting issues.
You see, now this court is really not concerned whether Chief Secretary or the forest is going to file the affidavit. The petitioner has canvassed its grievances before this court, which has to be adjudicated by this court. And you are officers of the court ultimately, right? Now you all settle among yourselves and file the necessary return to facilitate this court to adjudicate. Isn't it?
Yes.
So there is no...
I'm submitting on the basis of affidavit.
Correct, but I understand, Ms. Burman, but now they are also submitting something else. But in such a situation, how can this court function? One of you have to file the affidavit, otherwise we'll ask all the official respondents to be present in the court. Correct. If affidavits do not come, we'll ask them to be present in court, because we cannot decide who will file. You decide among yourself, Mr. Borthakur, because on the last occasion you said you want to file. Today you say it is somebody else. So decide and file whoever has to file. All right? You both cooperate with each other. All right? Yes, Mr. Sharma.
No, I don't have.
Mr. Borwa,
Because
sorry.
only matter is here, my lord. It is issue is involving from 2007 onward that PIL is coming up.
I understand.
And that this matter, sir, they're developing such a manner. Once we play this one, they go for other side.
No, but now unless
But anyhow, well, I will not done
Correct.
that.
Unless
I will not done that.
the
Let
affidavits
them
has
file,
to come,
let
right?
them file. Then a short date may be given because it will.
Let them first decide who will.
This case also 21.
Yes, I understand, Mr. Borwa, but the difficulty is they are
Yes,
not
yes.
even sure who is going to file the affidavit.
Yes, let them decide. Because Chief Secretary.
I am
himself
not
is there.
recording all this.
My lord, my
It
lord.
is not right. You decide among yourself and do whatever has to be done. Prothamat ki dila?
And interim matter maybe continue. That's all.
No. Earlier, who is R3?
Doctor, I am for R3.
You have already filed an affidavit. Mr. R3 is DC. So DC has already filed one affidavit. You do one thing, Ms. Burman. You have a look at both the cases and find out who has to now respond. If there is anything to be done from the office of the DC, you do it, and if it is not there, you file one-page affidavit and say that this is what you have to do, and then we'll deal with the forest of people. You make your stand clear, Ms. Burman. Likhila? However, then you write stop. It also appears that in WPC 313/2021, affidavit on behalf of R3 within bracket DC, jurisdictional DC, has already been filed. Stop. Fine. Then don't say. It appears in both the writ petitions. Affidavit on behalf of DC has been already filed. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Stop. Needless to clarify that if the forest respondents desires to file any affidavit in the matter, the same shall be filed by the next date of listing, failing which the matter shall be proceeded in accordance with law.
Interim,
if any, shall continue till the next date of listing.
Obliged.
In 36, my lord, we have filed a report today, my lord.
Report is in favor?
Yes, my lord. But not in record, my lord. We have just now.
It's not there?
No.
Tomorrow?
We are filing today, my lord. Today itself.
You are filing today?
Today.
So I'll post it on Friday, and I will ask the registry to place the affidavit on record so that we can dispose of the. M.S.M. Borman, learned government advocate for the state respondent, submits that an affidavit on behalf of the Chief Electrical Inspector within bracket respondent number
6, my lord.
Respondent number 6 has been filed today.
Yes.
Stop. However, the same is not on record. Let registry verify and place the same on record. List this matter again on Friday date.
My lord.
You've got a copy?
Yes.
In this case, madam, last occasion my learned friend.
Yes, return.
Last occasion, I had placed
You
before
had
this
received
honorable-
instructions.
Yes, Your Lordship, I had placed before this honorable court.
And you what?
Lordship, I was directed to file an affidavit. Lordship, what has happened is this instruction, I received it from the GMDA department, Your Lordship. I had prepared my instructions, my affidavit, and I have sent them for vetting and all. They are reluctant to file the affidavit because they are not made a party in this case, Your Lordship. GMDA is not a party.
Mr.
Number
Bora?
one.
My lord, I have been instructed, my lord, Lordship will make a party of
Yes, Your
GMDA
Lordship.
as well as Department of Housing and Urban Affairs.
No, but nowadays, you see, I think it is, they will have to file an application.
Yes,
Mr. Bora, I think,
But one thing is that my grievance is before the deputy
you see,
commissioner.
Mr. Bora, if you want an effective adjudication of the
Not
matter,
necessary, madam.
it may not be necessary, but they may be proper parties, because now
Yes, Your
the
Lordship.
instructions have
Yes.
come from those officers.
Yes, Your
Now, if they don't come on record, how do you want this court to adjudicate?
Deputy Commissioner selectively given the compensation by the
What is
Deputy
the
Commissioner.
difficulty, Mr. Bora, for filing an application and impleading them?
The GMC
You
and
file
the
it.
GMDA, Your Lordship.
I can direct listing that application on Friday also if you want. You can file it immediately, because nowadays this court cannot on its own,
Yes.
because there is a
Yes.
guideline. So you file an application.
But two departments have to file.
GMC and GMDA.
Department of Housing and Urban Affairs.
It is submitted on behalf of the MSN board. I'm recording her submission. MSN Borderloy Learned Standing Council Revenue Department submits that the instructions, that though instructions has been received from the
This one is from the GMDA department.
GMDA.
Urban, Housing and Urban Affairs.
Urban and Housing.
Housing and Urban Affairs.
Sorry, I didn't get it.
Department of Housing and Urban Affairs.
Department of Housing and Urban Affairs, Urban Affairs, comma, the same being not a party, arrayed party respondent in the matter, affidavit could not be filed.
Yes.
Stop. She further submits that GMDA and Department of Urban Affairs are both housing and so and so are both essential and proper parties for effective adjudication in the matter. Stop. In view of the aforesaid endorsement made by the Learned Standing Council Revenue Department, comma, let petitioner obtain instruction and do the needful in the matter. List this matter after
2 weeks.
After 2 weeks and a date to be fixed by the
Also,
registry.
Your Lordship, I would like to point out, Your Lordship, in paragraph number, the petition, the pleadings are not clear what type of a house it is, whether it is
Bottler, save that energy for the next date.
Yes, Your Lordship.
Yes.
I'm obliged, Your Lordship.
Yes, Mr. Das.
May it please, Your Lordship. Lordship, in this case, you are being led by Senior Counsel I. Chaudhary, but my senior is on legs. Lordship, may kindly pass this matter for time being.
Lordship, here instructions have not been received yet, Lordship.
Another date?
Lordship, if Your Lordship may kindly peruse the last orders.
Interim to be considered on the next date.
Lordship, on 26/4 also, Justice Michael had passed an order stating that the interim would be considered.
Mr. Counsel,
again on
you do
29.
not have to name the judge. I understand you are a flesh blood. Don't be so excited. When do you want it?
Lordship may fix it after a week.
No. There has the interim order needs to be considered. I can post it on Friday.
Lordship,
Is Friday convenient?
My
to
senior would like to argue it today, Lordship, because we have urgency in this.
I understand, but they have to also file, so I'm giving a short time.
Lordship, may kindly just pass it over for the time being. My senior is just on legs. I would like to argue this matter. Most obliged.
Yes, Mr. Banik.
My Lord, 14 writ petitioners are before your lordships.
Affidavits not filed?
No, Lordship, I just need 2 weeks time to file them.
You are on interim.
They might require more than that also.
Very well.
We'll be on a different footing, my Lord. They want to say something which they can address right away.
Mr. Banik, they have a right to file their affidavit.
Absolutely,
Let
not
them
on
file their affidavit. You are already on interim, so
Interim
we
is
will
only on
continue the
status quo,
interim.
my Lord.
Yes. How much time?
Lordship, after 2 weeks.
And you are for respondent number?
6.
Affidavit on behalf of R5 is already filed. R5, who is you have filed? Anybody else wants to file?
I'm from the department.
Because we will not go on keeping allowing affidavits to be filed. If anybody wants to file, please ask right away. Yes.
Been obtained instruction, Lordship.
You have obtained?
No, Lordship.
You are for?
Response number 1, 2, 3, 4, 5. Department.
Nambu Loilobo. MS so-and-so, Learned Counsel for respondent number 6, as well as MS so-and-so, Learned Counsel for respondent number
1, 2, 3, 4.
1, 2, 3, 4, 6.
6 only.
How much time? 2 weeks. 2 weeks time to file a return in the matter. Stop. Respondent number 5 has already filed their return in the matter. Stop. Prayer is allowed. Prayer is allowed. Needless to clarify that if the return is not filed by the next date of listing, the matter shall be heard in accordance with law. proceeded in accordance with law, and then interim order passed earlier shall continue till the next date of listing.
May I have a date?
List on date.
Iman? 17th of July.
After some time.
After some time.
May I plead the Lordship? My Lord, the petitioner is before your Lordship against the termination of his work order, my Lord.
Against what, Mr. Bora?
Termination of his work order, my Lord.
Sorry, I didn't get you.
The termination of
Termination.
Yes, my Lord. Termination of his work order, my Lord, at page 5, my Lord. Page 58, annexure 5, my Lord.
Affidavits, pleadings, everything completed?
Yes, my Lord.
Page?
Page 58, annexure 5.
Yes.
My Lord, the petitioner was awarded the work of padlocking of coaches at Guwahati and Kamakhya station, my Lord, and thereafter a...
Just one second. Yes, please.
And before issue, the petitioner was awarded the work of padlocking of coaches at Kamakhya and Guwahati station, my Lord, and thereafter a work
Padlocking
yes, my
of
Lord.
coaches.
Yes,
what
my
does
Lord.
that mean?
My Lord, the coaches are, when parked outside the station, the coaches are locked, my Lord. That is the work, my Lord. So, for that purpose, the locks were also supplied to the petitioner, my Lord, and they were performing the contract, my Lord. And after executing an agreement, my Lord. So,
Yes.
initially, the contract term was with effect from 26/5/2014 to 24/5/2016 for a period of 2 years. So, my Lord,
From which period to which period? 20?
26/5/2014
Yes.
to 24/5/2016.
24.
Yes, my
5,
Lord.
16.
16, my Lord.
Yes.
So, my Lord, initially in the month of December 2015, my Lord, a notice was issued to the petitioner at page 55, my Lord. Your Lordship will find it.
Yes.
In connection with the work of so-and-so, in spite of repeated instruction to you, the subordinate officers as well as by this office in various letters of event number so-and-so, you have failed to continue the work, so adequate process of the work mentioned above.
Yes.
So, my Lord, thereafter, my Lord, para 3, my Lord, as you have failed to abide by the instruction issued to continue the work to show adequate progress of work, you are hereby given 7 days notice in accordance with clause 62 of the standard general conditions of contract to commence works to make good the progress, failing which further action as provided in clause 62 of the standard general conditions of contract, namely to terminate your contract and complete the balance work without your participation will be taken. So in terms of the letter, after receipt of the letter, my Lord, the petitioner took all the steps, mainly, my Lord, on several occasions the work got affected due to, my Lord, because the locks are taken away by some strangers, my Lord, and due to unauthorized absence of the persons at work site, my Lord. That is normal procedure, my Lord, because locks cannot be guarded by the concerned personnel all the time, my Lord. So anyways, my Lord, in terms of this notice, the petitioner immediately responded at page 56, my Lord, and they resumed the work, my Lord.
Your reply is at page 56.
56, my Lord. In terms of the notice dated 14/12/2015.
That was a show cause and you
Show cause,
replied
7
at
days.
page 56.
Yes, my Lord.
Yes,
7
you
days.
resumed the work.
Yes, my Lord.
Yes.
Page 56, annexure 3, my Lord.
Resumed.
We are to inform you that we have resumed our padlocking services, so-and-so, so-and-so. And, my Lord, by the next page 57, by letter dated 23/12/2015, the petitioner was allowed to resume his work, my Lord, by the Railway Authority, my Lord. Then, my Lord, after about 4 months, my Lord, another notice has been issued. The page 58, my Lord.
Yes.
My lord, 7 days notice under clause 62 of general conditions of contract was given to you under the office letter number even so and so 14/12/2015. They are referring to the 7 days notice of 14/12/2015, my lord. However, from various inspection notes of officer and senior supervisors of so and so, it is revealed that you have not.
Which page is this? 14, 12, 15?
My lord, the initial notice of
Correct.
7 days.
Page.
Page 55.
Against which you've already resumed and they have allowed.
Yes, my lord. Yes, my lord. I have been allowed.
Yes.
So after 4 months, my lord, they have issued
Again
this.
referring to the same.
Yes, my lord.
Yes.
So paragraph 2 is that you are hereby given 48 hours notice in terms of clause 62 of general conditions of contract, and on expiry of this period your above contract will stand rescinded and the work under this contract will be carried out independently without your participation, and your security deposit shall be forfeited and performance guarantee shall also be encased, and consequences which may please be noted. So, my lord, this letter was sent to the petitioner by registered post. He received it on 29. Immediately on 34/2016, my lord, page 59, he approached the respondent authorities by filing a representation, my lord. My lord, on 30...
You received it on 29th? Yes.
Yes, my lord, 29.
You have mentioned at paragraph 3.
Yes, my lord.
Yes.
I have pleaded it in my... yes, my lord. So, my lord, by this letter, my lord, they approached the authorities, my lord, and it has been duly received at the office of the respondent authority, my lord. Down below the...
What happened after this?
After that, my lord, they issued the termination order at page 60, my lord.
So, your case is that you have resumed work.
Yes,
they
my
had
lord.
allowed,
Yes, my
despite
lord.
that they, without any application of mine, in a very mechanical manner.
Yes,
Is that
my
your
lord.
case?
Yes, my lord. And secondly,
But
my
what
lord...
is the stand of the...
And my lord, one important
because
thing...
I have noticed, I do not know
Yes.
the facts of this case, but sometime what happens, after an order for resumption, even thereafter, if there is slow progress or anything,
Yes,
sometimes these authorities go back to the very previous initial show cause notice, which
Yes,
is
sir.
obviously not correct.
Not correct. And
because
I will show you, my lord, what is the provision incorporated in the...
But in these cases, there must be an arbitration clause, Mr. Bora.
Yes, my lord. Arbitration clause.
Are you relying on Whirlpool?
Yes, my
Natural
lord.
justice?
Yes, my lord. Yes, my lord. Because if we rely on that, my lord, then we have...
Mr. Show me one thing. On what basis have you terminated? Where is the show cause? Because you see, the document at page 55, dated 14 something,
Yes, my lord.
is already became infructuous because you have allowed them to resume work.
And if
thereafter they have not resumed, or thereafter there is some slow progress, you are entitled under the contract to take steps. But for that you will have to first give a show cause.
So 7 days notice, which is
Correct.
stipulated.
So please show me if that has been done.
That is not there.
If that is not there, I am allowing this petition immediately because there has been a violation of natural justice.
Yes, my dear. Natural justice and
How can you
specific clause
terminate
of
the
agreement.
contract without giving any show cause, isn't it?
Show cause notice was given, my lord.
On 14.
For that is true, my lord.
That has become infructuous because
It
you
was
have
not
allowed
immediate,
them
my
to
lord.
resume.
It was not immediate.
No, immediate is different.
I mean, first serving the 7 days notice, and after if it is not satisfied
No.
with that, they can issue that other
that
letter.
first notice
Lordship.
against
It was in
that
12th December.
they have already resumed the work, and your office has allowed them to resume work. Correct. Thereafter, if
To
there
make
is
the
some
good, my lord.
development, then they are entitled for a fresh show cause notice.
That fresh show cause notice is not.
So then there is a gross
much I'll agree,
violation
my
of natural justice.
That much I'll agree, my lord.
So we will dispose it of then. You are entitled to
Well, in
take
fact,
whatever steps you want to
he
take.
has, the work he has done, my lord, all the bills have been paid, my lord. In fact,
Huh?
everything is ready.
On whatever work he has done, what?
The bills, my lord,
Are
which he has
prepared.
submitted, they are already prepared, but in fact, he has filed another
We
petition.
will not go
that
into
was
all
disposed
that.
of. Yes,
I am
my lord.
simply
That is a different aspect of
allowing
the
the petition by setting aside the termination order. You are at liberty to do whatever you want to do in accordance with law. All right.
And for your lordship references, page 43, your lordship may peruse where it has been stipulated that before issuance of the 48 hours notice, the 7 days notice should be there, my lord. 43, my lord. The relevant para starts at page 42, my lord. Clause 60. clause 63 down below E, page 42 E, my lord.
No, page 43 or page?
It starts at down below 42, my lord. Clause
Yes,
E, and relevant portion is at page 43, my lord. Then,
one second, can you read it?
Yes, my lord. 43, my lord. Then and in any of the said cases, the engineer on behalf of the railway may serve the contractor with a notice to that effect, and if the contractor does not within 7 days after the delivery to him of such notice proceed to make good his default insofar as the same is capable of being made good and carry on the work or comply with such directions as aforesaid to the entire satisfaction of the engineer, the railway shall be entitled after giving 48 hours notice in writing under the hand of the engineer to rescind the contract as a whole or in part or parts, so and so, so and so. So, my lord, it means that a 7 days notice should precede the 48 hours notice, my lord.
Which is the clause of the
Clause
7
63,
days?
page,
Huh?
page 41, my lord. The clause 63, determination of contract owing to default of contractor. 63E, my lord.
No, 7 days.
Yes, my lord. 6313E.
Yes. Being such a retired engineer.
Yes, my lord. That starts.
The relevant portion is at page 43.
43. It starts from page 42, my lord. Then and
within serve the contractor with a notice to the effect that 7 days notice.
Yes, my lord.
So first a 7 days notice has to be given. After that 48 hours notice.
Yes, my lord.
In your case that page is a 7 days notice, correct?
7 days notice was not preceded before issuance of the.
No, initially.
Yes, my lord. That was a 7 days
It was
notice.
issued, my lord,
14
but it was 4 months prior to that, my lord.
But
not immediate.
that is a 7 days
And
notice.
that has been complied with, my lord.
That I know, but that is
Yes.
the 7 days notice,
Yes, my lord.
correct?
That was 7 days notice.
That was at page 50?
55, my lord.
Alright. Disposed korim, huh? Manojit.
My lord, in fact, there is a provision for appeal also at clause 64, my lord. That he has not taken recourse to, my lord.
One?
Page 44, my lord. The clause number 64.
Page 44.
Lordship. Down below, my lord. Clause 60, settlement of disputes. If any dispute arises, my lord, he has to approach the general manager by filing an application. That he has not done so, my lord.
My lord, when there is violation of principle of natural justice, Harbangslal and other judgments, my
Please
lord.
please ask your junior to get me Whirlpool's decision.
Whirlpool
I
and
think
Hor-
1999 one
Yes,
decision.
Harbangslal is also there. When there is violation of principle of
Please,
natural justice.
you are carrying it?
Yes,
Are you
ma'am.
carrying it?
Yeah, I can get it, my
You
lord.
just ask him to immediately have it. Ask him to look into his phone.
Yes, my lord.
Nowadays, you don't need to go to the library.
Yes, my lord. Yes, my lord.
This is item number
58, supplementary 58.
Heard Mr. D.P. Bora, learned counsel for the petitioner, stop. Also heard Mr.
A. Borgoto.
A. Borkotoki, learned government advocate.
No, my lord, Railway Standing Council.
Learned Standing Council, Railway. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is challenging inter alia the letter dated 4/5/2016 issued by the senior coaching depot officer, whereby the work of, within quotes, padlocking of coaches at Guwahati and Kamakhya station Stick Line Guwahati and Kamakhya, Pit Line Guwahati, New Guwahati and Kamakhya for a period of 2 years, close the quotes, has been resigned. Stop. The case of the petitioner is that the petitioner was allotted the work of padlocking of the coaches at Guwahati and Kamakhya station with a contract agreement dated 25/9/2014 for a period from 26/5/14 to 24/5/16. Stop. Accordingly, the petitioner commenced the subject work. Stop. However, later on, the said work was terminated, for which the present writ petition has been filed. Stop. Mr. D.P. Bora, Learned Counsel for the petitioner, submits that the work has been terminated without issuing the 48-hour notice as required under the provisions of the subject contract. Stop. He accordingly submits that the termination order is in gross contravention of the provisions of the natural justice, and hence the same warrants judicial intervention of this court under Article 226 of the Constitution of India. Stop. Mr. So-and-so Borkotaki, Learned Standing Counsel, Railway, on the other hand, submits that though the 48 hours notice as contemplated under the contract has not been issued to the petitioner.
No, 48 hours notice was issued, but the 7 days notice that has to be preceded by that notice, my lord. That was issued in December, my lord.
Submits that the 7 days notice, which has to be preceded before issuing the 48 hours notice, was not issued in the subject matter, yet the same could have been taken before the Indian can be taken before the authorities of the railway in terms of clause 64 relating to settlement of disputes as provided under the contract agreement. Stop. Heard the parties and perused the materials available on record thereafter. It appears that the petitioner was awarded the work of padlocking of coaches at Guwahati and Kamakhya station in terms of the contract agreement dated 25/9/2014. Stop. It further appears that by letter dated 14/12/2015, the railway authorities issued a 7 days notice in accordance with clause 62 of the standard general conditions of contract to the petitioner to commence work / to make good the progress, failing which action as provided in clause 62 of the SSC i.e. to terminate the contract shall be issued. Stop. Pursuant to the aforesaid 7 days notice, the petitioner with a letter dated 21/12/2015 responded to the railway authorities that they have resumed the work of padlocking services at different places like Guwahati and Kamakhya station with effect from 21/12/2015. Stop. It further appears that the railway authorities, by letter dated 23/12/15, allowed the petitioner to resume the work with immediate effect as per the terms and conditions of the contract. Stop. Surprisingly, thereafter on 23/4/2016, it appears that the railway authorities issued 48 hours notice in terms of clause 62 of the GCC based on the 7 days notice issued on 14/12/2015 to the petitioner to resume work, else on expiry of the said period termination of the contract shall be issued. Stop. Thereafter, by letter dated 30/4/2016, it appears that the work order issued to the petitioner has been Thereafter, by order dated 4/5/16, 4/5/16, correct?
4/5/2016.
Thereafter, by order dated 4/5/16, the railway authorities terminated the contract agreement dated terminated the subject work allotted to the petitioner. Stop. In order to appreciate the rival contentions of the parties, pertinent to refer to clause 63, right? Clause 63 within bracket Roman 30 within bracket E of the contract agreement. Eto tumi quote kori diba. Yat page 42 I have indicated in quoted portion. It goes till Roman 2, right? 1 and 2 also will be relevant at page 43.
63.
Yes.
Yes, my lord.
Yes.
1 and 2 is also relevant.
A perusal of the aforesaid clauses in the contract shows that before terminating the work in connection with the said contract, a 7 days notice has to be first issued. Whereafter, if the work does not resume, another notice of giving 48 hours to the petitioner to resume work can be terminated in terms of the aforesaid clause. Stop. Next, in the present case, admittedly, the 7 days notice period, which was issued on 14/12/2015, was not given effect to, as the respondent authorities, after the petitioner resumed work against the aforesaid notice, allowed the petitioner to resume the said work. In terms of the as per the terms and conditions of the contract. Stop. Therefore, the action of the respondent authorities to issue the 48 hours notice after a period of after a period of 4 months,
almost 4 months, my lord,
without being preceded by a fresh 7 days notice, is per se bad in law. And is per se bad in law. Stop. The petitioner is entitled to the notice as contemplated under the agreement, failing which failing which there has been a gross violation of the petitioner's right of opportunity, contravening the principles of natural justice. Stop. Accordingly, this the respondent has already made the necessary payments. Stop. Mr. D. Gogoi, Learned Standing Counsel Forest, on the other hand, opposes the prayer for interim order. Stop. He submits that yes, what is the submission?
Before granting interim, the prayer, the whole issue needs to be better.
He submits that further time may be given for filing return in the matter. Stop. Heard the parties and perused the averments made in support of the interim order. Stop. It appears from clause G, it appears from the terms of purchase as set out in the contract document.
Yes, ma'am. This forms part of the contract agreement.
As set out in the contract agreement, that payment shall be made as per the schedule given below under clause G, which is reproduced hereunder for ready reference. Page 67, 1, 2, 3, 4 ke ase etu di dibo ha. Further, the termination of contract as provided in the said contract agreement specifically clause C of the said clause provides that the purchaser may at any time terminate the contract by giving 30 days written notice to the vendor. And one of the consequences of such termination of contract as provided under the said clause is blacklisting the vendor and cancellation of empanelment. Stop. Clause C of the consequences of termination of contract as set out in the said contract agreement is also reproduced hereunder for ready reference. Page 73. Quote kori disu moi. In the present case, it appears that that pursuant to the completion of the work, the respondent authorities has made.
The fact that they have made the payment is admitted in their show cause itself, which your Lordship will find at page 130. The show cause notice starts at page 129, and clause 6, para 6 at page 130 shows that they have released the entire amount.
Ki boli likhila? Comma, the final amount was released to the petitioner on 25/3/2022 by the Divisional Forest Officer, Eastern Assam Wildlife Division, Bokakhat, as seen from the show cause notice annexed as Annexure 9 to the writ petition. Stop. It further appears that pursuant to such payment being made without terminating the contract, the respondents has taken recourse. Don't say recourse. The respondents, by order dated 21/2/2023, has blacklisted has placed the petitioner company in the negative list of the Kaziranga National Park and Tiger Reserve, Assam Forest Department. Stop. Prima facie, the said order is per se bad and contrary to the provisions of the contract agreement itself. Stop. As such, a prima facie case, stop. Further, such actions of blacklisting has severe consequences on the petitioner company, which cannot be mechanically taken recourse to. Stop. As such, the said order dated so and so.
21/2/23.
It's there in the interim prayer, right?
Yes, sir.
Order, as such, the impugned letter number, it would pop up page 50, huh? KNP/FG/733/censor/NH37 dated 21/2/2023 is stayed until further orders.
Obliged.
I'm not saying list. Shall I give a date?
No, weeks, perhaps.
Let it come up after the vacations. Your Lordship may indicate after, listed after 4 weeks.
List the matter after 4 weeks on a date to be fixed by the registrar.
Obliged.
Item number 41.
Yes. None appears for the petitioner when the matter is called. You have received the CD. Mr. K. Kaushik, Learned APP for the state. Mr. R. Kaushik, Learned APP for the state respondent submits that the case diary received does not contain the up-to-date status. Stop. Accordingly, next prayer. Let the up-to-date case diary be produced on the next date. List on such and such date. Interim order passed earlier shall continue till the next date of listing.
42.
May I please, Your Lordship? 438 bail petition.
Yes, Mr. Kaushik. Await CD. List on such and such date. Interim order passed earlier shall continue till the next date of listing.
Item 43.
Yes, why is this matter for orders? Affidavit in reply you were supposed to file. Have you filed?
No, my lord. That's why I was saying.
Mr. Your name?
K. Vishwakarma.
As prayed for by Mr.
K.
Vishwakarma, Learned Counsel for the petitioner. List this matter after 2 weeks to enable the petitioner to file the affidavit in reply as prayed. Affidavit in reply as prayed earlier.
Yes, lord. I oblige, my lord.
44.
Yes, AO. This is applicable.
My lord, this is not applicable.
Not applicable.
Not applicable. Because in that case, the issue was that after GST cess will be leviable.
Very well. In that case, you have you filed your affidavit in this matter? Then you file it as prayed for by Mr. So and so Learned Standing Counsel. Learned Standing Counsel. ASAMB. ASAMB. Which is not opposed by the other side, list this matter after 2 weeks. After 2 weeks to enable the respondent to file their return in the matter.
Yeah, please, Your Lordship. My lord, kindly peruse the 29th January.
28th
January 2019 order.
Yes.
Agent for signed now.
No, who is appearing for? Tomorrow? Yes. When do you want? Friday?
Friday.
As prayed for, list this matter again on Friday.
46.
Your Honor.
Yes, what happened to the counter affidavit?
Your Honor, sorry, my lord. Item number 41. I was just outside. It has been passed. The
40?
order has been 41 actually.
Yes, what
Sorry,
happened?
Order. The order has been passed, and my name has been My name has been.
Please. Right now, you're obstructing the administration of justice. Item number 46 has been called. If you have anything, please say it after the list is over.
Okay.
Yes. Rupa Kudilova key problem. Yes, Mr. Chaudhary, you have filed. But it's not on record. There is no noting, nothing. On the last occasion, it says all the learned respondent for respondent number 1 praised 2 weeks time. Who is for R1? You are for respondent 1? Have you filed the affidavit? No. Have you filed the affidavit or not? Huh? You have filed. Have they filed?
Yes, Lordship.
You've got?
Yes,
when they filed it? Because there is no record, there is no noting in the file. Have you filed the affidavit, Mr. Counsel?
Yes,
when? You want to file any reply?
Yes, Lordship.
All right. As prayed for by Mr.
D. Burman, Lordship.
D. Burman, learned counsel for the petitioner, list this matter after 2 weeks to enable the petitioner to file reply against the affidavit, against the counter affidavit filed on behalf of respondent number 1 on 24/5/2024.
Lordship, a similar matter has been pending.
List this matter along with.
Lordship, a similar matter.
Anyway, next.
Lordship, that quantum case number 227.
Let this matter be listed along with.
Quantum case civil 227/2022.
We will see on that day. How does it matter? Yes.
Quantum matter will be listed together, Lordship.
I have already ordered. Why are you not attentive when I am passing the order?
Deeply obliged, Lordship.
Yes.
Well, in this case, we are going to file an additional affidavit.
This is the matter which a mention was made in the morning?
Yes, my lord, morning.
What has happened? Mr. Pukan, you are saying something?
My lord, it was part heard.
Matter shall not be treated as part heard.
Yes, it was heard.
So there were two occasions the matter was heard. On 25th and 9th of May, 3rd of June it was released. And now it has to come for hearing. Unfortunately, the matter is still the order call. Now he's filing the application today, which is quite voluminous. I want it to be left as it is. Matter can be posted for hearing any.
So what is this application?
Well, it is not. It is the document.
At the hearing stage.
My lord,
have you taken leave of the court?
My lord, it was my lord. Now it is orders, my lord. It was my lord. I have filed for vacating interim order, my lord. So,
your IA is for vacating the stay?
Yes, my lord. And thereafter, my lord, entire matter was heard, my lord. It was part heard and subsequently it was released, my lord.
Anyway, the matter needs to be relisted for hearing?
Yes, my lord. Yes.
In the meantime, if
any
additional
document be left, it will decide that the lordships can decide at the time of hearing. What
I'm not saying anything about
this.
this.
That will be fine.
It appears that this matter was earlier heard. It appears from the order dated 3/6/2024 that this matter has been released from part heard. Stop. List this matter for hearing. When?
My lord, this 18th of July, my lord, this proposed, my lord.
20?
18th of July, my lord.
18th July, is it comfortable? On such and such date. Stop.
Can it be 25th if not inconvenience to your lordships?
In the meantime, if you want, you file a reply to the that it is submitted that an additional affidavit has been filed in the matter. When?
Today.
Stop. However, today on behalf of the petitioner.
My lord,
on behalf of the railway department.
Yes.
Stop. However, the same is not on record. Let registry verify and place the same on record. List on such and such date for hearing.
18th of July, my lord. My lord, 18th or 20th?
25th, I said.
25th? 25th July.
Yes, my lord. File it.
In the meantime, Mr. Fukan, you want to file it?
Yes, I will. Grateful.
Item 49.
Made legal lordship.
Yes.
Lordship, in this case, I bet time to have instruction lordship.
Mr.
I am R. Islam.
Mr. R. Islam, learned counsel for the petitioner, seeks 2 weeks' time to obtain instruction in the matter. Stop. Prayer allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
Well, if that order has been complied with.
Orders complied? This is 50, no?
Yes, ma'am.
Mr.
S. Hawk.
Mr. S. Hawk, Learned Counsel for the petitioner, submits that during the pendency of the contempt petition, the order of this court dated 7/2/2023 has been passed in WPC 2525 of 2021 has been complied by the respondent authority. Stop. In view of the aforesaid endorsement made, nothing survives for adjudication in the present contempt petition. Stop. As such, the contempt petition stands closed. Disposed of. Yes, Mr. Chaudhary?
My lord, actually, the matter relates to a building which is being constructed for Central Administrative Faculty. Now, my lord, what has happened? Earlier, this particular plot of land was given to a particular school, but the school did not utilize the land for which it was given. Central Administrative Faculty. Not that the school was divested of everything, a reduced area was given.
The school authorities have filed this with petition. You are for the petitioner?
I am for the petitioner.
Yeah. There is a background.
And there is an IA?
Yes, there is an IA.
IA is filed by?
I filed the IA, my lord, for implementing, my lord. They are the successor committee of the school.
So right now the IA seems to be listed before this court. Any objection for the implement? No. IA to put us. So let me implement first.
Yes, my lord.
In IA 2951 of 2023. Heard Mr. H. Roman?
G. Alam.
G. Alam. Heard Mr. G. Alam. Sorry. Heard Mr. G. Alam, Learned Counsel for the petitioner. Stop. Learned Counsel for the applicant. Stop. Also heard Mr. K. N. Chaudhary, Learned Senior Advocate, assisted by Mr. D. Das. Assisted by D. Das?
Yes.
Assisted by Mr. D. Das, Learned Counsel.
We are for respondent number 329.
For Learned Counsel for respondent numbers 8 and 9. 8 and 9, huh? And Mr. as well as Ms. You are appearing? Ms. Gayan, you are appearing in this matter? And MS A. Gayan, Learned Counsel for CPW. Respondent number? 5. Mr. Hendik? Mr. J. Hendik, R3 and 4. Yes, Mr. Kalita Sharma. For R1. This is an application for impleading the applicants as party respondent numbers 10 and 11 in WPC number 2956 of 2022. Stop. Who are they?
My lord, is a school, my lord, and represented by the new committee, my lord.
You are the
new committee, my lord. Successor committee, my lord.
It is submitted. The applicants proposed to be implemented are the successor of the managing committee.
Yes,
of the petitioner. Stop.
In this case, we have filed an affidavit.
Accordingly, not according. In view of the aforesaid submission made, it appears that the presence of the aforesaid applicants is essential and necessary for effective adjudication of the writ petition. Stop. As such, the impediment sought is allowed.
My lord, in our affidavit we mentioned that this is a fake and false committee.
It's all right. You take your you file your returns. I am pleading them. Allowed. It is directed that so and so be implemented as respondent number 10 and 11. In Namgita at side over there. Allowed. And in the main case, let
on Wednesday next.
In the main case, let a amended cost title be submitted by the petitioner to the registry of this court for doing the needful. Stop. List
on Wednesday next.
On next Wednesday, date to date of time. On so and so date. I disposed of.
29.
Item 52.
May it please, Your Lordship.
Yes.
Lordship, on the last occasion.
Yes, Mr. Deori. Mr. Barthakur was supposed to file. PHE. You are for PHE?
Item 52.
PHE, anybody? You are Mr.
D. Roy, Lordship.
For the petitioner?
Petitioner, Lordship.
Miss D?
D. Roy.
Heard Mr. D. Roy, learned counsel for the petitioner. None appears for the PHE department when the matter is called. On the last occasion, time was sought for PHE department to file return in the matter. Stop. List the matter after 3 weeks on a date to be fixed by the registry. Needless to clarify, if returns is not filed by the next date of listing, the matter shall be proceeded in accordance with law.
Obliged, Lordship.
Yes, Mr. Deori?
Yes, Lordship. Lordship, this matter relates to payment of ex gratia to next of kin of the extremist killing, Your Lordship. So, the today listed is 192 of the 24. Your Lordship, here are again other two matters.
They are not before this court.
183 2024 and 185 2024. And in 183 2024, it was we have already submitted that the matter is 4 weeks time, and meanwhile the process has undergone.
When is that matter coming up?
That has been fixed after 4 weeks. So may I pray that this matter take along with
Mr. B. Deori, learned counsel for the respondent, seeks 3 weeks time to file return in the matter. Stop. He further submits that there are 2 other contempt cases related to the same issue pending before this court. Pending before this court. Stop. List this matter after 4 weeks. List this matter after 3 weeks on a date to be fixed by the registry, along with contempt case number such and such. Give the numbers.
4 weeks, then
Registry will see. I am saying with that.
Yes.
Give the numbers.
183 24 and 1.
Yes.
For hearing,
Which is this matter, Mr. Saraf?
On the last date.
This is that.
Hearing was completed before my side.
Yes,
no?
hearing
on the last date
completed,
only,
right?
Lordship directed me to the facts was to be added, my lord. The facts of the letters, etc. So for the convenience, my lord, in fact, what I have done, my lord, the earlier, my lord, your Lordship may, the earlier comparison which I gave.
Oh, this is that Century Plywood matter.
My lord.
All right.
The earlier comparison, my lord, I may take back. So I have included, my lord, the written submissions also, as well as the layman papers.
You do one thing, Dr. Saraf, ask your junior to verify this and take what is.
Well, otherwise there will be confusion. So, my lord, the green color binding. Yes, two sets. Yes, it may be written.
Write down and written.
Yeah, but your Lordship is marked, I think, something. So
yeah, a lot of things have been marked.
Your Lordship is marked as a new one, my lord. And
can you ask one of your junior to do it?
No, I can do it.
No, your junior will do.
Yes, yes.
Just mark the relevant page.
Somebody.
So
I'm so sorry I'm having to appear today.
Oh, this is close, but they have also filed the additional written submission.
Yes.
Malad, my apologies, Malad. I'm having to appear online today, Malad, because of some personal difficulty.
Mr. Sharma is appearing through video.
Yes, Malad.
I can hear you, but I cannot see you. It is on now.
Malad, my video seems to be on.
Where is that?
Lordship can see me?
We had already filed our written submissions.
No, but where is the additional
it must be
submission of
because
Mr. Sharma?
They have given copy to us.
Mr. Sharma, any local counsel assisting you in the matter?
Yes, Malad. Mr. Barun Deka should be there in court, Malad.
No, nobody is in court right now.
I will just, Malad, have them come over immediately, Malad. Lordships will keep it back for a while, Malad. I'll just ask them to be there.
I cannot hear you properly, Mr. Sharma.
Malad, I have just 1 minute, Malad. Malad, my network seems to be fine, Malad. Malad can see me? Your Lordship can see me?
Yes, now I can see you, but I cannot hear you properly.
I'm so sorry. Malad, we have filed an additional written submission, Malad, which was emailed to the court master.
Email Mr. Sharma, actually they have not, they're not sure about your additional written argument.
Very well.
Dr. Saraf says he has received it, but the court doesn't have it. Let
Very
me
well.
post this matter after 2 days. In the meantime, you sort it out. Ask your local councils to
we can give
serve
extra-
a hard copy. You
Yes.
have a copy.
Any case, my lord, I wanted to address arguments for just about 10 minutes, if your lordship says okay.
Mr. Sharma, there's a difficulty in hearing you. Additional written submissions on behalf of Mr. So-and-so on behalf of R7. Yes, I have got
Very,
it.
very well.
Well, I think
Very well.
Mr. Sharma want to address it, but as an intervener, there is no system of giving
It's
reply
all
from the
right, we can
intervener.
always hear. You
Yeah,
have
but-
already argued last
No,
time.
no, he has given the written submissions. Now again, my lord.
Mr. Sharma, the written arguments are already placed. If you agree, I can close this matter.
I would not mind. My learned friend raised certain arguments of prejudice, stating that, my lords, seems to be a nexus between the Union of India and myself, my lords. I only want to dispel
When should I fix this matter for further hearing?
next Monday, my lords, if your lordship pleases your lordship.
মোৰ থাকা নাথাকে নকয় তেওঁ ক'ব লাগে মইতো I finished.
Tuesday কিবা এটা থৈছো ন দুটা।
Monday is I think closed, my lord.
Monday is closed. Tuesday at 2 I have already fixed one matter.
I'll just take not more than 10 minutes. my lord.
Wednesday is another matter. And Thursday.
Then was it 20?
Thursday is Thursday convenient?
My lord, I have finished and I
Mr.
will not.
Sharma, next Thursday at 2
Next
o'clock
Thursday-
is convenient.
Yes, my lord. We'll do it on
Alright.
Thursday.
Huh? Oh, Thursday is fixed. Friday? Because what is happening now, I'm trying to fix matters which need some detailed hearing at 2 o'clock. So
Yes.
on Thursday also one matter is already fixed.
Very well,
Is
my lord.
Friday convenient? Next Friday?
Next Friday would be. My lords, keep it the Monday after that, my lords. Then.
All right. Okay, next week or Monday to do it. Okay. 24th.
Well, I will computer. I won't make any further submissions.
24th. 24 for fixed on 24/6/2024 for further hearing.
Great.
The copy. Extra pen উঠাই দিম।
You
Copy
can
sama আছে নহয়?
লৈ লওক। এই যোনবোৰ দিছে নহয়, একেলগে থৈ দিয়ক, হা? You have already given something in writing, right?
নাই, যিটো আমাৰ এটা set extra হৈ গ'ল। Client টো কাৰণে আছে।
You have made it. You are for R?
Flag লগাই দিব দেই।
This is Dr. Saraf's. R6?
Hey, Praveen, आपको ये flag लगा दी।
There is some confusion in these papers. So, since you all are here, maybe one of your juniors may just reorganize the written submission file. If something is not there, then you please give it a written submission to be here. Because it appears everything is in a very...
My lord, he will mark the 11% and so flag it, my lord.
No problem. They can give it
My
any
lord.
time of the day, no problem. All
I
right.
think well, it's the council for BIS also. Has to address for some time, I believe.
Very well. It's fixed on that day. Now,
On that.
whosoever wants, this court cannot force anyone to...
No, not at all. Of course
If
not.
anybody is willing, this court is ready to
And
hear.
my learned friend is saying that he made the allegation that they are selling in the same boat. Now, my lord, again he's saying that BIS has also, my lord.
No, I'm just for calculating the time on that day only for that particular
I
purpose.
think all of you can save your energies now for the next Monday.
Yes, very well. Monday, man. Lordship will say part heard also, Malak.
It will remain as part.
Yes, great.
File 2. Mr. Pathak, you got the file? Just check if you have those documents, just flag mark and just write respondent solution. Because it's slightly confusing. 62. Yes, which is this matter?
This was regarding a prayer for reinvestigation or fresh investigation by CBI or any other independent agency, because there was an FIR pertaining to the year 2006.
Mr. Chetia, you're appearing in this matter. Mr. Gogoi, you're appearing? Yes.
Please, my lords. My lords, this dispute pertains to the year 2006. So basically, I was residing in a house since the time of my father, since 1962. And there was an oral agreement that I'll be given that place after he passes away. And on that promise, we set up our shop in a house and we were residing. And after the landowner passed away, the legal heirs had some disputes, and there was a power of attorney which was executed in favor of one person who was an ACS officer at that point of time. And he sold that entire land to his wife. And that was without our knowledge. So when we were not in our home, we had gone to visit our daughter in Guwahati. When we came back, we realized that there was a 144 CRPC order that was being imposed, and we were being prevented from entering our own house. And thereafter, we had challenged that 144 order, and that was set aside by the court, saying that it was without jurisdiction. Be that as it may, after that, we had also filed a representation to the DC Dorong at that point of time in 2006, saying that we needed some protection because we were being harassed. And that representation was forwarded. My lord will have it on page number 59 of the writ petition.
Page number?
59 of the writ petition. So this is just the background, my lord.
Yes, yes.
Yes. So page number 59.
Is there a typed copy?
My lord, the type copy is there from page 57.
57?
Yes. The reason I am pointing out at 59 is for a particular reason, my lord.
Yes, yes.
This FIR was forwarded by the DC to the SP Dorong. My lord will refer to the top left portion.
Yes.
There's an official marking. SP Dorong for necessary action, please. Can my lord speak?
Yes, yes.
Yes.
Just one sec. Just read out this prayer.
Yes. Prayer for police protection against Nimai Saha, Ananda Saha, Dilip Chaudhary and Jayanti Saha. With reference, and out of that, my lord, Jayanta Sarkar, there's this person called Jayanta Sarkar, he was an ACS officer. It reads, with reference to the subject cited above, I beg to inform you that my husband Kishore Lal has been occupying the house situated in front of Jain Mandir, Kharupetia, as tenant since 1962. There was an agreement between husband and owner Zuram Saha that 2 kothas land in which we have been occupying as tenant would be sold.
So what is your prayer in the writ petition?
My lord, actually the main dispute arose when we filed an FIR.
Sorry?
The main dispute arose when we filed an FIR in 2006 because these legal heirs and this ACS officer, they constructed a wall in front of our house and they looted our house. There was theft in our house as well as the shop. So we filed an FIR. Then the police did not act upon it. So we were pursuing the matter.
Not registered.
The case was registered, my lord. The case was registered and it was registered as Dolgaon PS case number 270 of 2006.
FIR is dated?
FIR is dated 17/8/2006.
2000? 2006?
6. Yes. And it was registered under sections 448, 427 and 379
What happened
of
to
the
the investigation?
My lord.
3 times FIR is given also.
Yes.
It's a purely civil title suit was also.
So against the present FIR, which the petitioner is alleging that has not been taken up, against that FIR has already been done.
Also 3 times, not only single times.
And all the 3 times the trial court below had ordered for a reinvestigation. And in fact, this honorable court, there was a previous round of litigation, a writ petition was filed, where disciplinary proceeding was directed to be initiated against the investigating officer because he did not.
Where is the
act on
prayer?
it.
Which page is the prayer?
The prayer, my lord, will have at page number 29, my lord. It starts from 29.
To fix responsibility and accountability in not carrying out the investigation of PS case 278 and handing over to CID. Now, which is the order of the court?
The last order for investigation?
Yes.
My lord will have it at page number 156. It starts at 156. I would like to draw my lord's attention to the operative portion at 159.
156?
156 it starts, my lord. The operative portion, my lord will find at 159, where the very critical observation was made by the court.
You want me to go to page?
159, my lord.
159. Yes.
The second but last paragraph, my lord.
Yes.
It starts with this court.
Yes, I have got it.
Yes. May I read, my lord?
Yes, please.
This court, going through the case record of the instant case, indeed find that the IO investigated the case in a perfunctory manner. It is revealed that from the final report that the IO has not investigated the case properly and simply stated that the case has been established as civil dispute. It is also revealed that the IO submitted FR as per the verbal instructions of the Circle Inspector of Kharupetia and the additional SP headquarters, Mongoldoi, which shows that the investigation was done in a most improper manner, which does not befit a police officer. Hence, in view of what has been discussed herein above, the pair of the informant to direct the CBI or CID to investigate the case stands rejected. The power to refer the case to Honorable High Court for fresh inquiry through a special agency like CBI also stands rejected. However, the final report number 262/10/12 dated 26/7/2012 filed by the Dolgaon Police Station in Dolgaon PS case number 278 of 2006 is not accepted. For the ends of justice, I direct the officer in charge, Dolgaon Police Station, to reinvestigate the case further.
So what happened after this?
Nothing, my lord. No progress whatsoever.
You have not complied with this order. Mr. Gogoi, I am not on the merit of all this, but there is an order of the court of the judicial magistrate.
Yes.
Now, this is an order of a court. What has happened?
Paragraph 12 we have stated.
Paragraph 12 of?
Our affidavit.
What have you stated?
It is stated that case is now the case is now reinvestigated under the supervision of the CI Kharupetia Additional SP.
Mr.
And
Gogoi,
that was in the year
with all
2014.
fairness, the criminal court has directed isn't it?
Yes.
Reinvestigation. This is an order of the criminal court. This is not some administrative order which will be kept in the drawers of the officer. This is an order which has to be complied.
That affidavit was filed in 2013 also.
Which affidavit?
The SP Mongol filed an affidavit, my lord, in 2013.
As per 2013 affidavit also, that at that point of time, present status was this investigation is going on also.
After that, what has happened?
After that also, we have no instruction.
No, but I think
it was nothing is
no,
done,
but
right?
that is exactly what needs to be addressed before this court, correct?
Yes.
As regards what is the status of the reinvestigation?
That part I can obtain instruction.
I think it will be all fair that
part I
let.
can obtain instruction. Otherwise, also, rightly or wrongly, the magistrate passed the order, but he should exercise his own power also. After
You
submission of the
you have not challenged this order.
just I am
Then-
indicated. Just I am indicated.
As far as this court is concerned, orders of courts are not administrative orders. They are orders which has to be followed. If any party has any grievance, you know what is to be done.
Present status also I can place it. Otherwise,
All right, then I'll give them time to get the specific instructions as regards the steps taken pursuant to the order dated 6/4/13. Monajit. Upon commencement of hearing, it appears that the status of the reinvestigation by the officer in charge, Dolgaon Police Station, in the as regards the Dolgaon PS case number 278/2006, as directed by the JMFC Darang by order dated 6/4/13, is not available in the pleadings. Stop. Let Mr. K. Gogoi, learned additional senior government advocate, obtain instruction as regards to the status of the said reinvestigation and place the same before the court on the next date of listing.
May I just have a kind submission? My lord, the main objective of this writ petition was that we do not have faith in the state police machinery anymore.
I understand.
Because the judicial order clearly records
I
that.
understand, but before we proceed, before we proceed further, I think it is essential we know what has happened, because you have relied on this order, isn't
Yes,
it?
yes,
and
yes,
this order is already saying, because in this order the JMFC has rejected the investigation to be handed over to the
For specific
CID.
reasons, my lord. For
You see,
specific reasons.
the orders that you are asking from this
Yes.
court has already been dealt by the JFMC court.
Yes.
Which you have not challenged further.
My lord, that is
You
because
have
the
not
reasons
challenged.
have been
Now,
specified.
be that as it may, the JMFC court have said, all right, reinvestigate.
Yes.
But what has happened after that, nobody knows.
Yes.
So how do you expect this court to proceed further in the matter? Correct?
Yes, madam. Of course.
List again on
For reopening those.
date after the vacation.
19th July.
Yes. আৰু কিবা বাকি আছে? এটা টাইম বিং আছে নেকি? Which is the time bill? That is petitioner is not here? Then another date as prayed for 2 o'clock I have fixed a matter for delivery of some order. As prayed for, list this matter next week. At a date next week. Okay.
18.
Take down, huh? Combined order WPC 434 and then WPC 787. Mr. Buragohain, that averment in the writ petition is in which 434 or 787?
434, my lord, the first writ petition.
Okay.
At paragraph number 2, it starts.
Yes. Heard Mr. A.K. Bhattacharya, learned counsel for the learned senior counsel for the petitioner, assisted by Mr. H. Buragohain, learned counsel for the petitioners. Stop. Also heard Mr. A. Thakuria, learned counsel.
Not Thakuria.
A. Thakur, learned in the cause list. It is wrongly listed. That is what I was thinking last evening also. A. Thakur, learned counsel for respondent number 126, and Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. J. Patwari, learned counsel for respondent number 7. 7, right?
8. 7 is the other.
8 for respondent number 8. Anyone for 7? Anyone for 7? All right. Struck off?
Was struck.
Okay. The matter was taken up for hearing. Stop. Upon the arguments being completed from the side of the petitioner, comma, the respondent at the before the respondent during their turn, comma, raised the issue of territorial jurisdiction as a preliminary, raised the issue of territorial jurisdiction. Stop. Mr. K.N. Chaudhary, learned senior counsel, appearing on behalf of respondent number 8, further drawn the attention of this court to the pleadings in the affidavit in opposition where the issue of jurisdictional issue was categorically raised. Stop. In view of the objection as regards the jurisdiction of this court being raised, comma, this court is confining initially to the issue of jurisdiction before deciding the matter on merit. Stop. It is a settled law that issue of territorial jurisdiction in 226, in Article 226, has to be decided on the basis of the pleadings made before the court. Stop. Reference is made to the decision of Oil and Natural Gas Commission versus Utpal Kumar Basu and others, reported in 1994 for SSC 711. Stop. Keeping the aforesaid law laid down by the Apex Court, comma, the pleadings made in the writ petition are being considered. Stop. It appears from the averment made in paragraph 2 of the writ petition that before doing that, you add one more. The case of the writ petitioner is that the petitioner participated in the tender process pursuant to a NIT dated 10/11/2023, bearing tender dated 10/11/2023 for supply, fixing, testing, commissioning SITC of LED floodlights in Dampa Tiger Reserve Forest within bracket DTRF area from near BP number 2313 to near 2305/2-RI along Indo-Bangladesh border in Mizoram state within bracket approximately length 60 km. Stop. It is the specific case of the petitioner that after participating in the tender process and after submitting their bids, they have come to know that the two bidders, i.e. respondent numbers 7 and 8, are not technically qualified. Stop. Accordingly, the petitioners have submitted representation before the tendering authorities Stop. Failing any response from the tendering authorities, comma, the instant writ petition has been filed, wherein the petitioner inter alia is seeking direction to the effect not to accept the technical bids of the respondent numbers 7 and 8 in connection with the subject tender. Stop. It is the further case of the petitioner that pending the aforesaid writ proceeding, comma, subject work was allotted to the respondent number 8 by ignoring the representations submitted by the petitioner, for which WPC 787 of 2024 has been filed. Stop. In the said writ petition, the petitioner is seeking inter alia setting aside and quashing of the letter of award dated 30/1/2024 issued by the NBCC authorities to R8, right?
To R8, madam.
Why have you said R7 in your prayer then? It's R8, isn't it?
But here in 7, it's...
Anyway, Mr. Buragoy, just hear out the order. Any correction you feel issued in favor of R8. in connection with the subject tender. Stop. Since you, all of you have been submitting from both the writ petitions, there are flags everywhere. Now I am confused where I have flagged the relevant portions. Mr. Chaudhary, the clauses from the NIT that you had submitted about the submission of bid, that was from which writ petition? 434. Okay. It appears that the NIT dated 10/11/23, correct, was issued by the NBCC India Limited, Central Procurement Group, NBCC Bhavan, New Delhi. Stop. It further appears that it is specified, it further appears that the aforesaid NIT is for supply, fixing, testing and commissioning SITC of LED floodlight in the Dampa Tiger Reserve Forest area along with Indo-Bangladesh border in the state of Mizoram. Stop. The last date and time of submission of the online tender is 26/12/2023 and the place of submission is New Delhi as per the terms and condition of the NIT. It further appears that there is a provision for pre-tender meeting to be held on 22/11/2023 at New Delhi. Stop. It is submitted at the bar that the said pre-tender meeting as per the terms and conditions of the NIT was held on the prescribed day, on the scheduled date at New Delhi. Correct? On which date representatives of all bidders have participated. Stop. Paragraph 2 of WPC 434/2024 reads as hereunder. You quote paragraph 2, okay, at page 9. It is still page 12, okay? Stop. In support of the query of this court as regards the jurisdiction of this court, comma, it is submitted by the learned senior counsel on behalf of the petitioner that the impugned letter of award in WPC 787 of 2024 issued in favor of respondent number 8 has been communicated to the respondent number 8 at his office at Guwahati and from the office of NBCC authorities, New Delhi. Stop. It is further submitted that it is mentioned in the aforesaid impugned letter of award that earnest money, you said?
No, my lord, at page 71, the entire contract agreement clause, if your lordship is pleased to take up, there it is indicated that contract agreement would be signed at Guwahati.
It is for, what did I say? That in terms of the impugned, of the said LOA, comma, the contract agreement is to be signed at the office of the NBCC at Guwahati. Stop. That affidavit in opposition, Mr. Chaudhary, you relied is which writ petition?
434.
Yes, I've got it. Anything, Mr.
My
Buragohai?
senior is suggesting, my lord, the same clause also relates to the fact that they are to submit their performance bank guarantee and
That
security
exactly, that is what initially I wanted to write. That's why I asked you. Earnest money or something you had said.
So, in addition,
What is that?
It says, my lord, that you shall enter into formal agreement with NBCC on non-judicial stamp paper within a period of 30 days from the date of issue of this letter. Performance bank guarantee and 5 numbers of non-judicial stamp paper of rupees 100 each are required to be submitted by you in the office of CGM for entering into a formal agreement with NBCC.
Just add. He further submitted that the consequential submission of bank guarantee, etc., in terms of the aforesaid NIT is also required to be submitted at the said office of the respondent authorities at Guwahati. Stop.
Lord, that further means that partial cause of action, part of the cause of action,
yes.
Because of that arose here. That is our argument.
I understand. There, you see, that much there is no difficulty. If there is any partial cause of action arises, this court will have jurisdiction. Now the question is, what is cause of action? Because not any action, it has to be an integral cause of action, correct? I think that is how those decisions it have.
Which action is considered to be a part of the cause of action?
So I still don't know in which way my order will go. I am just dictating right now. But what I am thinking is, now in order to have a cause of, here what is under challenge? The challenge is the selection of respondent number 8. Correct? This is under challenge. Now the fact.
No, including the award, Miller.
Correct, but the award
process is one.
Absolutely, Mr. Bhattacharjee. Now your grievance is not about the submissions of the personal, the bank guarantee, etc. Correct? Your grievance is the issuance of the LOA. Now this LOA was issued admittedly from Delhi. Now merely because this was received at Guwahati, would that invest a jurisdiction before this court? This is the issue that this court has to decide. Have I understood this correctly or not?
Partial cause.
So this is what this
that
court...
is what we say.
Exactly. So this is what I shall decide. Whether because you have received it at Guwahati and consequential steps you have to take it in Guwahati, considering the challenge that you made, whether this court shall have jurisdiction or not. Correct? Yes, Mashwar, what did I write? I'm Guwahati. You say Mr. A.K. Bhattacharjee instead of saying Learned Senior Counsel. Name, okay? Mr. A.K. Bhattacharjee, Learned Senior Counsel. Now next paragraph you say Mr. K.N. Chaudhary, Learned Senior Counsel for the respondent number 8. Submits that no part of cause of action has arisen within the jurisdiction of the Guwahati High Court. Stop. He further fairly submits, assuming that part of cause of action has arisen within the jurisdiction of the Aizawl bench of the Guwahati High Court, comma, even in that situation, this writ petition, which has been filed before the principal bench, Guwahati High Court, without seeking permission, is not maintainable, inasmuch as no permission has been sought from the Honorable Chief Justice of the Guwahati High Court in the administrative side. Stop. Correct, Mr. Chaudhary? He further draws the attention of this court to the paragraphs. Which was those two paragraphs you have?
Paragraph 2 for the
10?
110.
110.
In our affidavit it is 1.
1 second.
Page 89.
110.
Lord Lecture reply. Blindly Lord Lecture.
There is some problem with the numbering of the pages.
Our page number is 89.
No, Mr. Thakur, actually, this court has already seen two paragraphs of their affidavit. That is why I want to rely that. Are you sure it is in 434? No, I was taking the other one. 109
it starts.
109.
Or 105.
Okay. Paragraph 2 at page, you reproduce, you had relied on paragraph 2, right?
Yes.
Paragraph 2 of the said affidavit, of the affidavit in opposition, filed on behalf of R8, which is reproduced here under for ready reference. Quote unquote, page 117 of 434 writ. The entire thing. The admitted position is that the NIT was issued from New Delhi for work to be commenced within the territorial jurisdiction of the Aizawl bench of the Guwahati High Court. Stop. Further, it appears that in terms of the NIT, bids were submitted before at New Delhi, and the pre-bid meetings were also held at New Delhi. Stop. It appears from the prayer made in both the writ petition that it is the factum of selection and the award of the contract to respondent number 8 is under challenge. Stop. There is absolutely no doubt as regards the fact that there is no part of cause of action as regards the selection process had arisen within the territorial limit of the principal bench, Guwahati. Stop. However, as regards the allotment of contract in favor of the respondent number 8, it has been contended that since the said order was issued by the tendering authorities from New Delhi to the respondent number 8 at his office at Guwahati within the territorial limit of the principal bench Guwahati High Court, this court has jurisdiction to adjudicate the writ petition. Stop. The issue that falls for consideration is whether merely because respondent number 8 has received the LOA, which is a subject matter, which is a challenge, which is challenged in the writ proceeding, whether this court shall have jurisdiction over the matter. Stop.
When 434 was filed, that cause of action did not arise.
Yes. You see, I have covered, I think I will edit it because I am saying that there is no doubt as regards factum of challenge. 434, there cannot be any doubt. But you see, for the second case, some cause of action they are showing has arisen. Now, whether those are enough to invest jurisdiction.
Para 6 of Uttal District.
Yes. So that is what, because you cannot say that nothing has happened in Guwahati. Respondent number 8 has received the award in Guwahati. They will submit the performance guarantee, everything in Guwahati. But whether because of all those, one can say that this court has jurisdiction in a matter where the LOA is under challenge. Because everything relating to the issuance, otherwise this court thinks, has taken place at Delhi. Nothing has done here. Now, merely because they've received, whether that gives them a...
That is enough.
Yes, yes.
So we have taken a preliminary point in our affidavit.
Oh, I forgot that. Mr. A. Thakur, learned counsel for NBCC, submits that that there is a jurisdiction clause in the contract, in the NIT or in the GCC, which is reproduced hereunder for ready reference. Clause 83.0 of the said GCC is 83.0. I have given it here. Huh? This one. Yeah. Then you write. Cause of action is nothing but a bundle of facts which has to be one second, huh? Don't say that. It is well settled that the territorial jurisdiction of a high court, that a high court will have jurisdiction if any part of cause of action arises within the territorial limits of its jurisdiction. Stop. In the Constitution of India. 226 line रखना 226 line रखना. Next, cause of action is a phenomenon well understood in legal terms. Stop. The collection of the words cause of action wholly or in part arises seems to have been lifted from section 20 of CPC, which section also deals with the jurisdiction aspect of the courts. The expression cause of action means the bundle of facts which it would be necessary for the petitioner stroke plaintiff to prove, if traversed in order to support his right to the judgment of the court. Stop. Stop. Reference is made to paragraph 38, 39, 40 and 41 of the decision of the Apex Court in the case of Naveen Chandra and Majithia versus State of Maharashtra and others, reported in 2000 volume 7 SSC at page 640. You quote these paragraphs. Huh? Can you say? paragraph 5 and 6 of the decision of the Apex Court in the case of Oil and Natural Gas Commission within bracket Supra is also reproduced hereunder for ready reference. Stop. A reading of the aforesaid decision indicates that not every fax would invest territorial jurisdiction in a court unless and until that fact, if proof that fact when proved, if traversed, entitles the plaintiff / petitioner to a judgment in his favor by the court. Stop. In the present case, what is challenged before this court is the factum of selection and the consequent allotment to and the consequent appointment of respondent number 8 as the selected contractor. Stop. The fact that the petitioner received, the fact that respondent number 8 received the said LOA at Guwahati, even if proved, does not entitle any relief to the petitioner, and hence cannot be said to be an integral part of the cause of action. Stop. In order to invest jurisdiction upon the court, the cause of every cause, the cause of action must be an integral cause of action, and not every cause of action. Stop. Keeping the aforesaid principles in mind, it appears that that part of cause of action has arisen within the territorial limits of the Aizawl bench of the Guwahati High Court. Stop. Appendix 16, next paragraph. Appendix 16 of the Guwahati High Court rules pertaining to the Guwahati High Court within bracket establishment of a permanent bench at Aizawl Order 1990 with a notification number GSR 599 within bracket E dated 22/6/1990 is reproduced hereunder for ready reference. You put this, huh? Though no cause of action has arisen within the jurisdiction of within the territorial limits of the Guwahati High Court, however, part of cause of action having arisen within the territorial limits of Aizawl bench, Guwahati High Court, this court is of the considered view that the matter be placed before the Honorable Chief Justice in the administrative side to take a decision in the matter in terms of the aforesaid appendix quoted herein above. Stop. Before continuing with further hearing of the matter. Stop. I think this is sufficient.
Yes,
if the Honorable Chief Justice says you continue, this court will continue,
yes,
because I have indicated that the petitioner has already completed its argument.
Considering the time factor given to the other side, would your Lordship like to say that status quo of the case as on today?
Mr. Chaudhary, not in this.
Because 15 months project was
the period is 15 months only.
I think I will inform the registry to place it immediately. I'm sure by next week this matter will be listed either here or there, whatever. And even if it goes to Aizawl, you can appear through VC now. There is no difficulty. I have taken up a lot of matters sitting at Aizawl bench through VC. Connections, everything is very good.
Only a technical issue.
All right.
Anyway,
We oblige, my lord.
Yes.
Deeply oblige.
Mr. Buragohai, I will,
Yes, my lord.
if I complete the order,
That's all right.
you before I sign, you just
My lord, may I just point out one thing? In writ petition 787, your lordship may put respondent number 8 as 7. And in 434, it will go as 8.
before I sign, I will give the order here.
Yes, my
you
lord.
have a look at
I'll
it
have
because
a
of the
look.
editing. Because that since two petitions together,
Yes, my lord, that is
sometimes
why.
it's very confusing.
Very confusing, my lord. Correct, my lord.
All
I'll
right.
have the order, my lord. Oblige, my lord. Deeply oblige.
All right.
Oblige.